You know, sometimes a document doesn't tell you what happened. It tells you what someone wants you to believe happened. And when you sit down with this 33-page motion for summary judgment, when you read it slowly, carefully, line by line, you start to notice something, not in Reed's conduct, but in theirs. Fear, contact, intent. 3 words they repeat like a mantra. 3 words they lean on to build their entire argument. But when you compare those words to the actual record, the record doesn't support them. It contradicts them. This episode of Delta Deep Dive is for informational and documentary purposes only. It analyzes public records, court filings, and legal documents. It isn't legal advice. It is a closer look at the truth inside the paperwork. This is Delta Deep Dive. Now let's dive a little deeper. The motion says it's simple. The record says it's not, because when you read this motion line by line, you start to see a pattern of omission, a pattern of framing, a pattern of selective citation, a pattern of pretending the record doesn't exist. They begin with fear. They write that Reed engaged in conduct that caused Vanginhoven to fear for her safety. Fear, a powerful word, a persuasive word, a word that carries weight in federal court. But the circuit court judge already ruled on this exact claim. He said on the record that no reasonable person would feel terrorized, frightened, intimidated, threatened, harassed, or molested by Reed's actions. That's the statutory language for stalking, and the judge said it didn't apply. The motion never mentions that ruling. Not once. Instead, it recycles the PPO petition, the same petition the judge rejected, and presents it as if it's evidence. That's not argument. That's omission. Then they say Vanginhoven reasonably feared for her safety. But reasonable fear isn't defined by feelings, it's actually defined by law. And Michigan courts have already answered this question. In one case, the Court of Appeals held that even a man who repeatedly slowed his car, stared at a woman, and circled her block did not meet the stalking threshold because there was no threat, no contact, and no intent. In another case, the court said that surveillance or observation must be paired with an intent to cause fear, not annoyance, not irritation, not rivalry. And in a third case, the court held that even a profanity-filled confrontation did not transform lawful conduct into stalking. Reed's conduct doesn't come close to those cases, and yet the motion treats it as if it's worse. That's not analysis. That's narrative engineering. Then comes their claim that Reed repeatedly drove past her residence. This is where the omissions become the story. They never say only 2 points of contact happened, because they didn't. They never say there were multiple points of contact. They never say there was a pattern of contact. They don't say anything about contact. And there's a reason for that. Because under Michigan's stalking statute, driving through a public alley, even multiple times, does not count as a point of contact. Not legally, not factually, not under any interpretation of the law. A contact requires something directed at the person, approaching them, following them, confronting them, communicating with them, sending messages, calling, showing up at their door. Those are all forms of unconsented interaction. Reed did none of that. He drove through a public alley, a place anyone can drive, walk, or film while documenting residency. That is lawful observation, not contact. The record reflects that. The police report shows 0 unconsented contacts. The PPO hearing shows 0 unconsented contacts. The Escanaba public safety investigation shows 0 unconsented contacts. The deposition matches 0 unconsented contacts. So instead of confronting the number 0, the motion avoids the word contact entirely. Because the moment they use the statutory term, the statute does the rest. You cannot have a course of conduct without 2 or more unconsented contacts, and you cannot turn lawful driving in a public alley into a contact, no matter how many times it happened. That's not analysis. That's the law. Then they write that Reed's behavior demonstrates an intent to cause fear. Intent requires awareness, purpose, choice. You cannot intend to frighten someone you don't know is there. And the record shows Reed didn't know she was home, didn't know she was watching, didn't know she was filming. He didn't know she was upstairs, and he didn't know she was behind the blinds. The motion omits all of that. It omits the judge's ruling. It ignores the Escanaba public safety findings, and it omits the deposition admissions, because these documents don't fit the story. They then write that the record supports her fear. But the motion never cites the transcript, never cites the judge's ruling, never cites the police report, never cites the dismissal, and never cites the deposition admissions to the fact that there were no points of contact. Because those documents don't support fear, they contradict it. The motion reads like a press release. It's polished, it's confident, it's persuasive, but it's not accurate. It's built on omission, on framing, on selective citation, on the hopes that the reader won't notice what's missing. But we notice because we've seen the record, we've seen the documents, we've heard the testimony, we've watched the videos, we've listened to the judge, we've followed the timeline, and the truth doesn't bend to narrative. The motion says it's simple. The record says it's not. This is Delta Deep Dive. Follow for more.